Okay, we're continuing on copyright. Here we've just talked about the kinds of things that can be protected. Now, works that are not eligible for copyright protection. The Copyright Act does not protect facts and ideas. No one may claim originality as to facts because facts are not authored, they are discovered. However, a compilation of facts may be sufficiently original to justify protection. Um, well, let's see if it's the next one. Let me see. Can I copyright the laws of gravity? Think about that. Copyright Act does not protect procedures, processes, systems, or methods of operation. However, works that fall into these categories may receive protection under patent law, and this is according to page 165 of our book, our textbook. That's another thing. We're going to do copyright, trademark law, patent law. It's all very important. Now, the Copyright Act does not protect, and here we go. I always like to show off some of my French. I took a summer of French, and I don't know very much. I don't remember very much, but it's sans affaire. Sans affaire. What does that mean? Stock or standard expressions of an idea customary to a particular genre, which Packard says on page 165, refers to situations in which there is essentially no other way to express a particular idea except by using certain elements. Now, Ivan Hoffman, an attorney, says, quote, one of the elements necessary to have a work be copyrightable is originality. Generally speaking, the bar is set quite low in determining such originality. However, where there is no other way of saying, photographing, or otherwise creating an idea, the courts prevent the monopolization of that idea through the application of the above doctrines. Thus, while substantial similarity may be a basis for infringement where originality is high, in these instances, a claimant has to show that the copy is virtually identical. So, have any of you attended a murder mystery dinner? Anybody? Anybody? Now I have the hiccups. Well, there's no other way to say a murdery mystery dinner. Try it. That's what they are, murder mystery theater, but where's the dinner in there? Anyway, it's one of a kind. It's a one of a kind thing, and the only way you can describe it is murder mystery dinner. Now on 17, it also doesn't. This is interesting. I've always marvel at this. Titles and names are not copyrightable. I can put out a movie next year that's the same title as a movie that came out this year. It's been done many times. I can come out with a book with the same title as a book that was written, I could come out with Gone with the Wind, and I don't even have to call it Gone with the Wind 2. It can be called Gone with the Wind. Also, short phrases and slogans, except for those protected by trademark. Familiar symbols or designs, variations of typographic ornamentation, lettering, or color. However, typographic computer programs are copyrightable. Now, 18. U.S. government documents. Remember, we own U.S. government documents. We're taxpayers. We paid for those things to be created. These are works created by federal employees in the course of official duties. C-SPAN video of House and Senate floor proceedings are in the public domain and not protected. But House and Senate committee hearings and White House briefings are protected. Probably I'm not sure about the White House briefings. Those must be the ones that brief the president. Those get into areas of secrecy, privacy, that sort of thing. Works in the public domain, like I said before, category of works that never had or no longer have copyright protection. That's the meaning of copyright, or that's the meaning of public domain. Category of works that never had or no longer have copyright protection, freely available for anyone's use at any time for any purpose, without payment, without credit. Who is the copyright holder? Copyright vests in the creator of a work at the moment of creation or production. If two or more people create the work, they share ownership of the copyright. Works prepared by an employee in the scope of employment is considered a work for hire, and the copyright belongs to the employer. And this is why I tell you, if you ever have a great idea for a product, for a dress design, whatever, do not, I repeat, do not create it or draw it or write about it on company time on their computers. If you do, the company will take it. So that sort of thing, aside from work, ideas for inventions, that sort of thing, do it on your own time, on your own computer, and you will have the copyright. Don't let your employer take your intellectual property. How long does copyright last? Well, works created since 1978 last for the life of the author creator plus 70 years, expiring at the end of the calendar year. So that would be December 31. A work for hire, or a work that is anonymous or pseudonymous, is protected for 95 years after the date of publication, or 120 years after the work is created. Prior to 1978, copyrights were protected for 28 years, with the option to renew for another 28 years. This was then extended. So as of January 2012, any work published or copyrighted prior to 1923 has expired. All right, so if we're talking about 2020, any work published or copyrighted prior to 1931 has expired. Had to do the math there in my head. Copyright and freedom of expression. The Supreme Court has described copyright as the engine of free expression, adding that, quote, by establishing a marketable right to the use of one's expression, copyright supplies the economic incentive to create and disseminate ideas. It's kind of amazing that people 250 years ago, forming a new nation, thought of this. They thought of everything. Our founding fathers were brilliant. Yes, they didn't put everything in, but my gosh, what they thought about was just astounding. So slide 23, fair use. Oh, does that ring a bell? Fair use of a work, even without permission, is allowable by the Copyright Act. Favored uses are criticism, comment or commentary, news reporting, parody, teaching, scholarship, or research. I don't have to ask the author. I can use a phrase or a quote from a book, and as long as I cite the author and the date and the page that was on, I have the right to use it. And we talked about, here we go, we talked about the criteria. Courts determine fair use on a case-by-case basis after considering these four factors: the purpose and character of the use, the nature of the copyrighted material, the amount and substantiality of the portion use in proportion to the work as a whole. For example, I gave you the example, I supplied you with chapter 1 of our book. There are 12 chapters. So you could say I provided you with 1/12 of the content of the book, which is okay. They usually say no more than 1/10. 1/12 is smaller than 1/10. Or I could have said, what I'm giving you is 20 pages, and the book is 200 pages. There's 10%. That's okay. The effect of the use upon the potential market for or value of the copyrighted work. As long as I'm not taking money out of the hands of the person who wrote the book. Packard gets money every time one of my students purchases a book. Plagiarism and copyright infringement. So what's going to happen? Plagiarism becomes copyright infringement when copyrighted works are not cited, and when copyrighted works are cited incorrectly. What if you took a quote from one of my papers and you put Dr. Pamela Morris's name next to it, but it was actually something I said? Well, then you've infringed on my copyright, and there are penalties for it. We're not going to talk about Creative Commons. So anyway, that's the beginning. That's copyright for you.